you said you're absolutely right. Alex Ozols, thank you so much. Let's go in together live. Let me see if our legal analyst guests agree. Still on the program, criminal defense attorney Alex Ozols still with us. And just joining the program, criminal defense attorney Silva Megerditchian. Okay, Alex, I want to go to you first. Thoughts on what the judge just said to counsel?
He just called out the defense counsel. Like, how exciting is that? We've been waiting for that. He said he was going to object. He considered unilaterally objecting. And he's probably, the funny thing is, like, I've been in so many of these trials, and the judge looks at you and kind of like nods their head, like, come on, object, object. And the defense counsel was doing nothing. He calls him out and he says, I even considered objecting. It's like the witness is saying he's, a special specialist handling special duties in a special office. And it's like, okay, like what we all had no idea what we were getting at here. But the judge called him out. It was crazy.
Right. And then the point is, it's like, okay, so you're a special guy with a lot of, accolades, but what do you know about the case? Let's get to the point, right? Give us the facts. Silva, what do you think about this, please?
Julie, I've been watching your coverage since the start, and every time that you were frustrating saying, where's the objection? I was like, oh my God, where are the objections? This was narrative. Where is the objection for narrative? It's, I'll never forget, and Alex, I know you can agree with this too, my very first trial as a public defender, I was doing this horrifically long closing argument. I look over and I see a juror is literally dozing off. These are human beings. They're exhausted. They have to listen. And they, just like all of us, after a few minutes, our minds go to Europe. So I don't understand the reasoning. These are seasoned attorneys. It has reached a level of ridiculousness. So I share in the viewers' frustrations. And Julie, every time you said something, I was in the background going, oh my God, yes.
I was reading your mind, Silva. Yes. In the minds of many of our Court TV viewers who are so awesome and have been live tweeting throughout this thing. This is really something, and there's more to come. And Silva and Alex, you're going to stay put and give us some more analysis. We want you to stay put at home. Thank you. Let's bring back in our legal analyst guests. Still with us, Alex Ozols and Silva Megerditchian. Okay, so there we have it. Nobody is asleep. But jurors, sometimes they do fall asleep. It happens. They doze off or catch themselves starting to doze off. And here, that last bit of information elicited from that DOJ agent was bordering putting everybody into Napville. Silva, talk to me about what the state needs to do to solidify this case as they're nearing the end. We know there can't be much more in their case in chief, but what do you think may be lacking before they reach the point where the defense moves for judgment of acquittal?
I feel like the jury is honestly waiting for that, bam, that's it, something to grab onto, something more. And I feel like the prosecution, though there is a lot of circumstantial and direct evidence, there's just nothing to push them over. That's how I see it. So I think the prosecution needs to come up, kind of like a Chanley analysis, where they really outline everything about this case in a very succinct and simplistic way so the jury can follow it. But I'll be honest with you, Julie, I don't think that succinct and simplistic is what these attorneys are doing. I'm just hoping that they don't fall into kind of this lengthy monologue that's, again, going to lose the jurors, especially when there's no direct evidence to see in this case. So they really have to focus on why their theory is that he absolutely did it. And right now, I just don't see it.
I'm with you, Silva, and I think many viewers are, at least the ones who've tweeted at me about this, and I like what you said, A plus B equals C. Yes, you want something formulaic. You want a legal theory that everybody can understand and follow through the case. Here, they've taken like the A through Z approach, and they're throwing it all at the jury. Alex, do you feel that way? And tell me, this morning, I know you were watching and into this afternoon when our show started at midday, the strangulation was brought up. And for the first time, I was listening to the testimony kind of feeling like, okay, is this where the prosecution's legal theory lies? What do you think?
No, so I mean, it may be where their legal theory lies, but they're not exposing it or bringing it out. A lot of this stuff, it's like they're asking people these questions, these witnesses who are not experts in this field. They can't testify to any of these facts. We have a police officer can't testify, and they'll be like, oh, have you ever handled a case with strangulation before? Okay, well, let me get your expert opinion on this, basically. They can't do that. And so we hear these like little facts they're bringing in, but these people can't actually testify to it. And Shanley made a good point. I mean, the jury's fallen asleep. When you have a prosecutor just continuously going on a narrative the entire time, it's going to make the jury fall asleep. And the defense has to take some tips from the judge here. I mean, if a judge ever made any indication that someone gave too long of an answer, I'd be objecting on every single answer after that, because I know the judge is vibing with me and he's agreeing with me. So I don't really know what the main point of the prosecution was to bring up those small facts, but they never really developed them.
Right, I'm with you. Can we talk about the objections and lack thereof just for a minute? Because I feel like this trial has me getting so frustrated. When I look at the prosecutor, and I'm talking about the female prosecutor, she's really done most of the questioning in this case. We've seen her advocacy far more than we've seen her co-counsels. But it's very clear she has a good handle on the rules of evidence, because I see her objecting very quickly, citing a basis whenever she does it, when the defense goes to cross a witness. Yet, she thinks it's okay to do what is improper and against the rules, and that is lead every single witness through their direct testimony. So that frustrates me that she's not following those rules. And then what frustrates me equally is that opposing counsel is just letting her do it. And like, to your point, Alex, the judge is even saying, hey, I was thinking about objecting to this, but I didn't want to do it. I didn't want to do it in front of the jury. But come on, Silva, tell me more about what you were thinking as you've been watching this trial, and what you would be doing if you were on either side in terms of these objections.
Well, as a defense attorney, Julie, absolutely, I would be objecting. And not only just because there are legitimate objections, but also to put a little bit of spice. Unfortunately, again, trials have to be interesting. They have to be compelling, especially a trial like this. You know, it's interesting. It almost made me wonder, again, prosecutors, attorneys in general, they're going to try to do whatever they can. And if there's no objection, they're going to go forward. Even if it's improper, even if it's unethical, if the other side doesn't catch it, they will go on as much as they can to get what they want out. Now, there could be some kind of internal agreement here. You know, I did this once with a prosecutor I knew for a long time, which was, look, I'm not really going to object because I want all of the evidence in. I don't want the jury to think that I'm hiding anything, so they're going to hear everything. And who knows, that could be a little agreement that either one of the attorneys has, or both, that they don't want to object because they don't want to show the jury that they have anything to hide. So let's flush it all out there and let the jury decide what they want to do with it. I think it's a counterintuitive way of doing things, especially for a trial like this where you don't have direct evidence. I think, again, it's really a disservice to the defendant, and really just a disservice to the whole process. It's gone too far. So I feel like, again, the judge did a great job saying, guys, let's get on this.
Yes, yes. Bravo to Judge Atkinson. Bravo, absolutely. Alex, give me your final thoughts, please, before we have to take a break.
Yeah, I mean, this objection thing's pretty crazy. I'm getting tweets about it. I'm getting people text me that are watching it. I mean, people are talking about this. It's gotten to the point where the general public is even saying, hey, make an objection, which is crazy. So, I mean, if people aren't watching this trial, they should be, because it's really exciting. And, I mean, people know what's going on here, which is just crazy. So I'm excited about it.
Right. Yeah, it's great. It's, you know, and so many non-lawyers will say, hey, I'm not a lawyer, but I'm even getting frustrated wanting to object. And I'm like, yes, you've got it. You know what's up. You watch court TV and you know when you need to object. And these possibilities have been endless in this trial. Alex Ozols, we want to say thank you so much for your insight and expertise. You're going to be leaving us, but Silva Megerdician's going to be staying with us for the next hour.